All right, so this is for a guy that just sent me a complaint. All right, and I'm just gonna explain a few things. Usually, this right here is the caption. Okay, this whole area up here, just so you guys know, this right here, this is the caption. All right. Now there's the names, the parties, the names over here, and then there's a cause number, a court number, case identifier, something that you always tell the court or something. Now I want to point out some things here. All right. A copy of this complaint has been attached. All right. This right here is the summons. This whole thing is a summons. So I probably should have let off with that, huh? This is the summons. This is the caption. All right, now there's some instructions here that you got to really look at. All right, the complaint is attached. So you're going to receive a complaint. All right, you're going to receive a complaint here from somebody. I'm not sure, they're going to be up in here. And chances are you're going to know who they are. So just keep an eye out for that. All right, now you do have to file an appropriate response within 30 days of service of the complaint or petition. Okay, so they served you today, then tomorrow is day one. So you have 30 days from today. Whenever you got this thing, you have 30 days to appropriately respond. Okay, now in order to know how to appropriately respond, you have to look in your rules of civil procedure. Okay, every state has rules of civil procedure, so does the feds. Okay, they all have rules of civil procedure, and you have to go look up how to properly serve. Okay, how to properly serve this complaint. This stuff down here, this is just for the process server. Don't pay, I'll just go over real quick, but this is not for you. Okay, this is not for you. This is for the process server. They're supposed to deliver this thing within 3 weeks after this thing is filed at the courthouse. But this is not for you. Don't worry about this stuff right here. All you need is a response within 30 days. Okay. Now, I'm going to go over here to the complaint now, okay? This is the actual complaint right here, okay? It is a complaint, and this is your title right here. There's your cause number up in here. This tells you where you're at in the district or superior court of wherever you're at, okay? Wherever they're claiming has jurisdiction, okay? Now, jurisdiction is important because it's usually geography, okay, where an event took place, okay, an event, some sort of event, right, because somewhere a court has to be able to handle disputes between people when they fight. So, if two people are fighting in New York, how would a court in Alaska have jurisdiction? You know what I mean? It doesn't make sense. A New York court would have jurisdiction to hear any dispute. All right. Now here you have the name of the plaintiff and the defendant. All right. Now here's one thing that makes me laugh. Comes now. Yeah, you coming now? Is that what you're doing? This is stupid talk, man. Okay. Please do not put this in your paperwork. Don't talk like this. Talk normally. You talk normal. Comes now, Bob Joe Smith, by and through the people of such and such on behalf of the Castle of Grayskull or some shit. You know what I mean? Come on. Nobody talks like that. Talk right. Talk right. Don't emulate bad attorneys. Okay? Talk right. Talk normally. Okay? and remove your emotions from your body. If you can't do that, well, then you need to get help from somebody to look at your documents and be like, dude, it sounds like you're a mad old lady or something, you know. Like you need to be cool, talk right, okay. Sorry, talk right or well. Sorry, I shouldn't put that. Talk well, okay. When you read your documents, you should read them out loud so you can hear what you sound like, okay? And if you sound angry, then you need to rewrite it. And always say, when you do read it out loud, say it in the most angry voice possible. You know, like, comes now, blah blah blah, by and through counsel. Like, it kind of sounds like you're a dick. You know what I mean? But if you say, what they're really trying to say is that the plaintiff is represented by this person. You know, this person is representing the plaintiff. That's all they wanted to say. That's all they had to say. Here are the grounds for the modification of a decree. That's all they're doing. But they don't do that. They talk like this. That's a real big thing. Please stop talking like that. If you want a judge to read it, then don't talk like this. This is crap, okay? So here, these are just some facts here. A decree was entered in the above matter awarding plaintiff the custody of the parties' minor children. This is a fact, but it's very vague, okay? All right? Like, what kind of custody? What custody? You know, what is custody? What is custody here? All right? We need to challenge this. We would write something back that says, hey, this is real vague. What kind of custody? You know, what do you mean? How is this material? First of all, how is this a material fact? There's facts, okay? On this day, whenever the decree was entered, the sky was blue. That's a fact, okay? But is it material? Nah, it doesn't mean shit. So we don't need to put it in there. But this right here is a vague fact. And the reason why I'm starting here, and you might be like, oh, well, this is like blah, 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 blah. Nothing. Because maybe you're somebody who's actually, you know, been pro se before. Well, if you don't challenge it, you waive your right to dispute it. You must challenge it. So we challenge this as being vague. Okay? It's not a material fact. It's not important here. What kind of custody? Once you elaborate on custody, maybe it's a material fact. But no, why include this? Okay. Now, this court has jurisdiction over the parties and subject matter. Now, there's two things. There's personal jurisdiction and there's subject matter jurisdiction. Personal jurisdiction has to do with geography. Okay. This one, subject matter, is exactly what it says. Like, subject matter. Like, what is it? Are we fighting over who stole whose gum? You know, did you steal my gum out of my candy cabinet or something? Well, you're not really gonna find any legal remedy. Like, there's no law that says that you're entitled to that you can sue somebody over them stealing your gum. You know what I mean? Like, unless that gum was chewed by, you know, George Washington or some shit, and that's important to you. But otherwise, you've got to have a legal remedy. We need to know, what is the subject matter jurisdiction? Maybe they have personal jurisdiction and geography or something like that, but you challenge that as well. And eventually, in your response, you will challenge these jurisdictions. Okay, you will challenge them. You will challenge jurisdiction, okay? Geography and subject matter, all right? Now, here the plaintiff is a resident of such and such and defendant. So here they're trying to establish this right here. They're trying to say, well, that's how this applies. So, okay, you got to challenge all that, okay? The minor children have resided exclusively with the plaintiff. What does this mean? Resided exclusively. Like, this is vague. Okay, it's prejudicial too, all right? I don't know if I spelled prejudicial right, but, and I know I'm writing like a doctor, but I'm not a doctor. Prejudicial means like, dude, come on, you didn't have to say that kind of stuff. You know what I mean? Like, oh, you don't do your job right at work. Like, you're a bad programmer and you're fat and you're ugly as shit. That's prejudicial, man. Like, you may be a bad programmer or a bad architect or something, but your weight and your looks and your personal appearance, that has nothing to do with it. That's prejudicial. So this right here is well, why resided exclusively? You trying to say something bad? Trying to say something bad happened? Like, what happened? Like, that's vague. Explain it. Now, since the entry of the decree, a material change of circumstances has occurred. Okay. Well, I assume they're going to talk about those material circumstances. Okay, defendant's earnings have increased to a point where the application of child support guidelines would increase his support obligation by more than 10%. Oh yeah? You have proof? Do you have proof? Do you have proof? Okay? We challenge that. Do you have proof? And is this a phishing? Okay? So is this a phishing scheme? They don't really know that your income has changed. They just want to find out what your income is, you know. And under the law of your state, it's probably legal for them to do this. But you want to challenge it anyway. All right. Now, okay. So I can hear some of you in your head saying, what, you know, some of the more experienced pro se are going to be like, well, this right here, child support doesn't even apply because you're going to challenge it in subject matter jurisdiction. And that is true. You are going to challenge subject matter jurisdiction. This right here is their subject matter jurisdiction, is child support, right? They're saying the court has the ability to solve problems involving child support. All right. Now, and you're going to challenge that. You're going to say, we're going to say no. Here, we're going to say no. The court actually doesn't have subject matter jurisdiction. Okay, that's a long video right there. So we'll talk about that later. But here, at times, it has not been the minor children's best interest to be in the care of the defendant because of his behavior. Okay, let's look at this. Because of his behavior. What kind of behavior? Like, this is vague right here. This is vague and prejudicial. Okay, I want proof. Like, where's your proof on this one? Now, we may very well say that the court does have jurisdiction here. Okay, we may say, yeah, you only got jurisdiction, but only to enforce my equal and 50 custody contract without child support. You may be able to enforce that one, but you can't enforce this order or decree because this one is void because there was no law that allowed them to have jurisdiction. And now I'm getting off into into all the stuff that requires another video. Okay, that's the conception contract stuff. Okay, guys. So just and gals, just that's just how it is. Okay, I'm not gonna talk about that right now. That's another video. But this one right here is we want to see proof, you know, and not been in the children's best interest, you know, and at times. We will take this all apart. At times, what do you mean at times? How many times? Like one time? One time? You're coming for one time. Why? Oh, well, because he spanked a kid because the kid ran out in the street. Oh, shit. That's not even... What? That's vague. I mean, not vague, but that's irrelevant right there. Like, that's allowed. You know, like the kid ran out in the street. Like, that's not a basis for a claim. You have no claim to that. You know what I mean? One time he spanked a kid because he went out in the street. Get out of here. Get out of here. That's crap. You cannot invoke jurisdiction off of that. Okay? So we end up doing that later on. All right? But this is how we tear that one apart. And there's one more page here. Okay? One more page. And then we get to go home. All right. Now, wherefore? Okay, come on, please don't talk like that bullshit. Talk well. All right, write well. Don't write like that. Write well. Write like you talk. Write like you speak. Okay, do that when you're in there. Don't get all crazy with all that stuff, and try to keep your stuff minimum. I know it's hard, you know. You want to go off and you see people talking about case law, quoting the Supreme Court and the Constitution. Don't do that. Don't do that right away. Okay? Don't do that right away. You'll see in other videos where you leave that stuff out for another day until you finally get the real. You want 2 to 3 good case law and stuff. You don't need 50,000 of them, okay? That's not going to help. You want the judge to read this stuff. All right. Now, let's get on to this real quick, and then we're going to go bye-bye. All right. Plaintiff prays for an order modifying the previous order. Okay. So they want an order modifying the previous order. This is what they want. This is their goal here. All right. This is their goal. Let me do this real quick. This is their goal. Bam. Let me get the little blue right here. This is their goal is right there. Okay. That's their goal. And they want to modify the parenting plan for the best interest of the minor children for an increased award of child support. So they also want increased child support, and they want attorney's fees. And this right here, this claim, any such other relief as the court deems just and equitable. Okay, this right here, you need to object to this statement right here. Usually it won't hold up, okay, because if you don't ask for it, you won't get it, okay? If you don't ask for it, you won't get it. But this statement right here, if you don't object to this statement, you're going to have to fight it later on, and a much harder fight. You need to object right here. This is a no-no and a no-no. Big no-no. And this one, well, that's a no-no too. That's not going to happen. That's not going to happen. Okay? And this may happen though. This may happen because you're going to say, okay, I will agree to modify the custody order, but not the way that they want it. It's the way I want it. Something that's fair. Okay? We are going to ask for something that's fair. And that is 50-50 and pay your own damn. I did that on purpose. Okay? I misspelled damn wrong. I did that on purpose. I don't want no emails about that stuff. Don't be telling me, hey man, you spelled damn wrong. I don't want to hear it. I don't want to hear it. All right, look. This is basically how you tear down an initial pleading, an initial complaint, a motion to modify, a complaint to modify, stuff of that nature, and how to know that there's a summons, and then the summons has to come with all legal stuff. It comes from the courthouse, and then this part right here is what the lawyer types up. Okay, I'll tell you right now. I give this lawyer like a 1 out of 50. Yeah, this lawyer right here, he's a 1 out of 50, and so he sucks. Okay, he sucks. If you pay for an attorney that does stuff like this, that's vague. If you look at it and it's vague and it doesn't have very good facts, you have a really bad attorney. Okay, that's how you know. So if you do want to look at an attorney, go ask them to see some of their pleadings, and if they talk, if they don't write like they talk, and they just kind of like go off on all this stuff and they're very vague, then they're a bad attorney. Okay, find another one. All right, you guys have a good one. Talk to you later.